In this video, I want to introduce you to the FRQ type known as SCOTUS Comparison. SCOTUS is an acronym that stands for Supreme Court of the United States. And as that title suggests, you're going to be comparing cases decided by the Supreme Court. Like the other two that we've already been introduced to, this FRQ is weighted the same, and you're expected to spend about 20 minutes on it. But this is the FRQ where your knowledge of those 15 must-know court cases really comes into play. And if you haven't believed me yet about how important it is to know those cases and know them well, I think you will see that this FRQ really does require good knowledge of them. The SCOTUS Comparison FRQ, as I said, requires you to demonstrate your knowledge of a must-know case. You'll be given a brief summary of a Supreme Court decision that you probably do not know, but then you will be asked to compare it to one you do know. So you'll receive all the information you need about this new case. You will have nothing but the name of the must-know case. This FRQ is scored out of 4 points. Part A is worth 1, Part B has 2 points, and Part C is worth 1. Part B, which is often the case, is going to be the most important part. This is where you're really going to earn the points. My advice is when you receive this FRQ, you do not read the summary of the new case. You skip past it and you look carefully at all parts of the question, parts A, B, and C. Do that first. The reason for doing this is simply that students will, if they read that summary about the new case first, they are more likely to get confused. My advice is that as soon as you read the questions, and as soon as you know what the must-know case is, the one that you should already have knowledge of, you begin to take notes, and I like to say you brief the brief. So you think about that must-know case that you learned during the year, and you jot down, okay, what are some of the key facts of this case? What was the constitutional principle or clause that was central to that case? And then finally, a couple notes on what did the court decide. Get that down first before you start to cloud your mind with the details of this new case. At that point, you can now read the summary of the new case, and you should quickly start to see some similarities between the two. Part A is really simple. Part A will ask you to simply identify the constitutional principle or clause that is common to both cases. That will not be explicitly given to you in the summary of the new case, so you really are dependent on your knowledge of the must-know case. That's why I said when you brief the brief, you should note what was the clause or the principle that was in that case. Now also be careful. A few, just maybe a couple of the must-know cases that we studied involve multiple clauses or a clause and a principle of government, like federalism. The answer to Part A is going to be one single clause or principle, and it'll be only the one that is only common to both cases. So if the must-know case maybe involves 2 clauses, when you read the summary of the new case, you should be able to identify which of those 2 clauses is also in this one. Part B, as we said, is the most important part. And it's going to ask you to do 2 things to earn these 2 points. First, you will have to demonstrate your knowledge of the facts of the must-know case. And I am going to show you an example in a little bit and how to go about doing this. But you will earn 1 point if you effectively show your knowledge of the must-know case and the facts of it. Now, the facts don't have to be incredibly detailed, but enough that the reader of your exam will say, okay, you do know that case. The second point will come when you explain why the court reached either a similar ruling in both cases or a different ruling. The College Board uses the word holding instead of ruling, but there's no difference. You want to know what the court decided in your must-know case, and then you're going to compare that to what the court decided in the new case, and you're going to have to be able to explain why the court reached those similar or different holdings. My advice when you write these, the response to Part B, is that you do these two things separately. You actually write two separate paragraphs. In the first paragraph, you summarize the must-know case. So again, you kind of brief the brief. You talk about the facts of the must-know case, you identify what the clause was, and then you briefly explain what the court decided. Do that, you'll earn that point. Then skip some space, and now compare that to the new case. Doing this separately helps the reader see that you're earning each of the points. As I said, in Part 1, write a brief of the brief. In Part 2, be sure to compare the holdings of each. And my advice is when you are comparing the two cases, whether you're asked to show why the holdings were similar or why they were different, you use phrasing like I've included here on the slide. You say things like, in both of these cases, the court interpreted the free speech clause of the First Amendment in this way. Or, while in case A, the court ruled this way on the free speech clause, in case B, they said this. Okay? That type of phrasing shows that you are comparing. Finally, Part C is going to take this in a different direction. This is actual language from the College Board, which I know is very wordy, but this is what they're looking for in Part C. They want you to describe or explain an interaction between the holding in this new case that they've given you and then some relevant political institution, behavior, or process. In other words, they want you to connect what the Supreme Court decided in this new case, the case that you've just been introduced to, and connect it to something else you know about government. Another governmental institution like Congress or the president, a political behavior like maybe voting or protesting, or some sort of process of government. These vary widely. They're usually not too challenging. Take a deep breath, think about what you know about government, and you can answer these with relative ease. Here's a couple examples of what they might ask you in Part C. They might say something like, what could Congress do if they disagreed with the court's ruling? And your answer might be something as simple as they could perhaps pass a law that is worded a little differently that the court would uphold, or maybe they would propose an amendment to the Constitution that would force the court to rule differently in the future. They might ask what the president might do. They might even ask what the public might do, what you as a citizen or a voter might do if you disagreed with the court's ruling. Another example is, how could an interest group use the holding to advance their agenda? Remember, interest groups are very interested in court decisions and litigation. They file amicus briefs. How would an interest group take this decision and use it to advance their policy agenda? That's what they're doing there. All right, that is your introduction. Now let me show you an example of a SCOTUS comparison FRQ. So it'll look something like this. Here is that summary of the new case. Usually it's a couple paragraphs long, not too long. Remember, we don't want to read that right away. That'll confuse us. We want to look at the questions. When I look at the questions, of course, the first thing I'm looking for is, what is the must-know case? Here it's McCulloch versus Maryland, a case we study early in the year. I then want to, in the margins or somewhere on this page, I want to jot down some quick notes. What was McCulloch about? Well, let's see. Congress chartered a national bank. The state of Maryland levied a tax on the bank. The president of the national bank in Maryland refused to pay the tax. Next thing you know, we're in the Supreme Court. Okay, some basic facts. What were the key clauses in the Constitution or key principles that the court was looking at? Well, you might recall this involved two. It involved the necessary and proper clause. Is it necessary and proper for Congress to charter a national bank? And then it also involved the supremacy clause. If Congress can charter a national bank, does that bank become supreme over the state of Maryland's law, the law that taxed the bank? And hopefully you'll remember the court's decision. They said that, yes, it was necessary and proper, so they upheld the Congress's law that chartered the bank, and they declared that Maryland's tax on that bank would violate the supremacy clause. Of course, the principle at play here is federalism. This is a case about federalism, and it involves those two clauses. Part B asks us to explain how the facts of McCulloch, so once again, we have to demonstrate our knowledge of those facts. And now the facts of Arizona, the new case, led to a similar holding in both cases. So I would underline or circle the word similar as a reminder that I'm going to be comparing similar decisions. I shouldn't, and this is really a safety net. If you can't remember what the court said in McCulloch, you would at least know that the decision is going to be similar to what they're saying here in Arizona. Now, of course, that word might also be a different holding in both cases. So that's why it's important to identify that word. And then finally, Part C, describe an action Congress could take to respond to the Arizona decision if it disagreed with it. Okay, and that's that example I gave you earlier. Let me show you how to set up this response. Now remember, Part A is very simple. You are simply asked to identify the common, you know what, I see a typo here. The question should have said clause, not principle. There is a difference. Constitutional clauses are actual clauses found in the Constitution. Principles may not be stated in the Constitution, but we know the Constitution gives us them, things like federalism or judicial review. So it's the clause that we're interested in here. But the common constitutional clause in both of these cases is the supremacy clause. Now remember, McCulloch also featured necessary and proper, but Arizona did not. So there's only one common clause, and we have to make sure we're identifying the right one. Notice that this is a complete sentence. It's a simple sentence, and I even underlined the heart of the answer. Supremacy clause is what they're looking for, but we'd never want to write anything but complete sentences in an FRQ. So if you simply answer A, supremacy clause, you will not earn the point. You're not telling them the common clause in both. They don't know what that means, supremacy clause. You want a complete sentence, even one as simple as this. Now notice the way I've structured B, and I'm going to point out that this is not necessary to have this third paragraph here. It's actually the second paragraph. I said earlier that 2 paragraphs is ideal for Part B. But some students do like to put this other one in. That's your choice. But the first paragraph is my summary of McCulloch. It's my brief of the brief, where I am showing the reader that I do know the facts of that case and the decision. And I think that's exactly how you want to write it. Lay out the facts in several short, simple sentences. Congress passed a law chartering a national bank. Maryland levied a tax on that bank. The cashier of the bank refused to pay it. Case went to the Supreme Court. Okay? Then describe the court's decision. The court ruled in favor of the federal government over the state, citing the supremacy clause, which makes federal laws supreme over state laws. The court ruled that Congress's power to charter a national bank was supreme over the state's power to levy taxes on that bank. Okay? That's a really good, concise summary of McCulloch. Clearly earns that point. Now, the next paragraph that essentially does the same thing, but summarizing Arizona, like I said, is not necessary. You are earning no points for this. let's be honest, they just told us about Arizona. You're just simply summarizing what they told you. Okay, why would they give you a point for that? But some students do like to write this because they feel like in order to compare them, they kind of got to lay out both. If you want to do that and you feel you have the time, go ahead. It might also help you in understanding how they are similar or how they are different, should they be different. So that's really a judgment call on your part. But if you do it, make sure that you skip space in between so they can see that that's what you're doing. But the final paragraph here is a must. This is the comparison. Notice that I'm using a lot of sentences like both cases, right? Both cases featured a conflict between federal power and state power. It's about federalism. In McCulloch, the court ruled that the federal government's power to charter a bank was supreme over the state's power to tax it. Likewise, in Arizona, the court ruled that the federal government's power to make immigration laws was supreme over the state's attempt to do the same. So, we didn't read the case together. Maybe you paused the video and read it yourself. But Arizona was a case in which the state was trying to make immigration laws, but clearly the federal government has the delegated power to make those laws. And so you had a federal law and a state law in conflict. The federal law was supreme. And I capped this paragraph by again saying, in both cases, the court based its holding on the supremacy clause, which makes federal laws and powers supreme over the state's laws and powers. I think it's very important when you're comparing these cases that you kind of answer this question. What did the court tell us about the clause, or what did the court tell us about the principle in both of these cases? Did they tell us the same thing about the supremacy clause? Or did they tell us something different in each case? Now, because these two cases are similar holdings, we would assume that what the court told us is similar about the supremacy clause. But if they were different holdings, why? Why did they interpret this case using the clause one way, but they interpreted the clause differently in this case? And it'll all be because of the facts. There are different facts at play. Finally, part C, again, a relatively simple answer. This is one sentence, which rarely is good enough, but it might suffice here. Remember, they want to know, what could Congress do if they didn't like the decision in Arizona? And the answer simply says, Congress could vote to propose a constitutional amendment that would transfer the power to regulate immigration, from the federal government to the states. We could change the Constitution. Immigration laws would no longer be a federal power, a delegated power belonging to the federal government, to Congress. We could make that a state power, a power reserved for the states. It's one thing Congress could do if they didn't like that decision. So again, keep this simple, tie it to the facts of Arizona, and you will be fine. All right, this sample will be available in Canvas, so you can look at it a little more carefully and maybe model some of your responses off of it. Hopefully this helps. The SCOTUS Comparison FRQs are not that bad, but again, you see very clearly how important it is to know your must-know cases, so continue to review them as often as you can.